Thanks for joining us.
No, thank you.
So you've been quite involved engaging with the engineering field. You had a presentation with Engineers Australia, for example, and you collaborated on this paper. So why you as an industry lawyer, why are you choosing to engage in this discussion, co-write a paper with us and really try and speak to engineers?
Probably a couple of reasons. I've been writing about the problems with safety management from a legal risk management perspective for a long time now. But a few years ago, and this really sort of sparked me into this area, there was a series of papers and articles and books that sort of came out and said the WHS legislation has come into effect. It introduces this so-called new test of so far as is reasonably practicable. It is fundamentally different from the old test of as low as reasonably practicable, and we need to approach all of this completely differently, which I thought was just, it was wrong. That's wrong. It's factually wrong. It's not what has occurred. I found it very misleading, and I found it creating a lot of confusion. And the more I got involved in those conversations, I came to realise how much confusion there actually was within an engineering community about this test of reasonably practicable and what it means. Ideas around things like a LARP being some sort of legal test, which it's not. Tolerability, again, being some sort of legal test, which certainly in an Australian context, it isn't.
So in simple terms, what does reasonably practical mean under Australian work health and safety law, and why is it such a central idea that's applicable to dam owners?
Well, reasonably practical, and I need to make the point because this is where we get confused. The defined term is reasonably practicable, and people often think the defined term is as low as reasonably practicable or so far as is reasonably practicable. And as low as or so far as are simply the precursors to the word. The definition is reasonably practicable. And there's two parts to it. So in layman's, or paraphrasing if you like, the definition of reasonably practicable goes to what an organisation knows or ought to know about a risk, about a hazard, so what can cause harm, the risks represented by that hazard, how likely is it, what are the consequences going to be, and what the organisation knows or ought to know about the controls to mitigate, eliminate or mitigate those hazards. And then there's a balancing exercise where we have to understand what's the availability and suitability of those controls, and underpinning it all, there is a cost test which talks about the cost. You don't have to implement something if the cost is grossly disproportionate to the risk. Now, you won't find cases that talk about cost. It just doesn't come up in the cases. Practical terms, when we're having arguments in court, when we're in prosecutions particularly, and we're having arguments about what's reasonably practicable, what we are talking about is whether the organisation has got proper systems to manage the hazards in the business. And proper systems is really about, do your processes align with the regulations? Do they align with codes of practice? Do they align with standards? Those sorts of things.
Can you explain if ALARP and risk tolerability, especially as outlined in the ANCOLD risk assessment guidelines, are legal concepts in Australia, or better down from legal concepts, and how these terms are related to the obligations under work health and safety legislation?
Okay. They are not legal concepts in the sense of a prosecution. So a prosecutor will never allege that a risk wasn't tolerable, or they will never allege that a risk wasn't ALARP. The argument will, the way the prosecution frames their charges is to say that the organisation failed to do everything reasonably practical because it did or didn't do X, Y, and Z, and then they'll set out the particulars of the charge. And the only time I've seen tolerability come up is where the court has said the question of whether or not an organisation decides something is tolerable is not an answer to the question of whether they've done everything reasonably practical.
Completely separate. Yeah. So given that ALARP and risk tolerability are not legal concepts, why should it matter to dam owners that they are basing their decisions on these terms and concepts, especially if the decisions they've made have resulted in there's been no dam failures while they've been basing their
sure.
decisions on
Yep.
those concepts.
We do safety management to keep people safe, people and communities safe. But one of the very real consequences of a failure to get safety management right is legal consequences, and the legal consequences have been moving very rapidly up.
Mm-hmm.
So why should I, as a duty holder, let's put it even more broadly, should I as a duty holder under health and safety legislation be concerned about whether our processes to manage risk are aligned with the legislation? Because it creates legal exposure. That would be the simplest answer to it.
Yeah.
If you set up your own policies and procedures and you define reasonably practicable different, or you substitute it with a LARP, or you use tolerability, again, that's your business.
Mm-hmm.
You use whatever language you like to describe whatever you do. If something goes wrong, you won't be held accountable against the standard that you've described in your system. Right. You're held accountable against what the legislation says. Yeah. And this is kind of a frustration. So everybody talks about legal compliance as a minimum requirement, mm-hmm. okay? Which I think really misunderstands legal compliance, but leave that to one side. I would have thought that if legal compliance really was the minimum expectation, then you would just take those definitions and say, this is the foundation we're going to use, mm-hmm. to build our framework to manage risk.
Yeah.
We don't do that. What we do is we create phrases like tolerability, mm-hmm. which often get applied in practice in ways that are not consistent.
Yeah, and another example would be ALARP, from some concept or some acronym of reasonably practical.
Whereas in the health and safety legislation, we have a very prescriptive definition of what we have to consider for reasonably practicable.
So you've been involved in inquiries and prosecutions. From your experience, what do courts or investigators actually examine when something goes wrong? And how could this inform dam owners?
Your risk profile and your conversations about tolerability and ALARP will form part of the evidentiary mix in that balancing exercise between time, effort, and resources versus what's the risk we're dealing with. Yeah. Now, the exposure, or part of the exposure in that conversation is that your risk decision-making processes will be heavily scrutinised.
Okay.
So the decision-making that led you to that point will be heavily scrutinised. I think the best example of that, if people are interested, is there's the presidential inquiry into the Deepwater Horizon disaster. That's page 125 of the presidential inquiry. And on there is a table of decisions, and it talks about what the decision was, whether there was a less risky option available, mm-hmm. whether the riskier decision saved time or money, and who was the decision maker.
Yeah.
And I think if you look at a table like that, you get a sense of how your risk decisions get scrutinised when things go badly wrong.
So if you were advising a dam owner today, what would you say they should focus on to ensure their decisions on dam safety are legally defensible?
The one thing I always tell organisations, do you have proper systems to manage the risks, and are they implemented and effective? Mm-hmm. And that's when ultimately if something goes wrong, that's the conversation we're having. What did you have in place to do the risk assessments, to make the decisions about what's an acceptable level of risk, about how the risks are going to be controlled? Were those systems being complied with?
I think you really said earlier, having a technically good risk assessment and having a risk profile sitting somewhere doesn't mean you've done everything reasonably practical.
No, it does not.
Yeah. As a follow-up then, why is it so important, or why do you think it's so important for technical guidance to be legally coherent, not just technically sound? I think that goes back to the point you mentioned about not proposing to be technical legal guidance.
I think we want it to be legally coherent, mm-hmm. because part of the risk is if it's not legally coherent and we have incidents and those guidelines are found not to be suitable in the context of legal risk management, the guidelines lose credibility. And I think that's problematic. We need credible technical guidance that we can point to as industry to say we relied on the technical guidance in part to help manage our legal risks. So I think the credibility of the guidance is important. And I also think, and this conversation has sort of borne it out, and what I referred to as the earlier conversations about this distinction between so far as and as low as reasonably practicable. At the moment, it strikes me as a very confused conversation, and I don't think that's helpful for anybody.
Yeah.
So if we can get a more coherent conversation, if everyone's on the same page, understanding at least if we're all on the same page and saying this is what our legal obligations look like,
Yeah.
you can, as an organisation, you can take legal risk. You can say we are making a decision to have that threshold and to put things below that. We understand that's technically not what reasonably practicable means, but we're going to wear that risk of efficiency, thoroughness trade-off, and you're making more informed decisions. I think at the moment people are making decisions thinking they're managing legal risk, when in truth I don't think they are.
Who would be the appropriate entity to define a tolerability threshold or framework for an organisation or for a dam owner?
The organisation.
Yeah.
It's the organisation's risk appetite that should be defining it. Even so, the health and safety legislation, which is the framework for protecting people, does not define a tolerability or any other threshold.
Yeah.
It sets the test, which is reasonably practicable.
Yeah. And before we wrap up, what key messages would you want dam professionals, including owners, regulators, consultants, designers, to take away about their duties under work health safety legislation? The first part is to understand what the duty requirements under the legislation are. But fundamentally, I think the key thing organisations need to pay attention to, and I've said it a few times, but it's always where we end up, is whether or to what extent the organisation has got proper systems to manage the hazards in the business, and what assurance do we have that those systems are implemented and effective. Well, thanks for your time.
Pleasure.
Thank you.
Pleasure.